Assalamualaikum. Good morning, everyone. It has been an interesting morning session listening to Dato Mohamed and Prof. Zaliha talking. There's some questions that I think which I can answer a bit later on as well. I'm basically an anesthetist. So if by the end of this lecture, most of you are like that, I can understand. I won't be offended. Now, this tombstone you seldom see, but as doctors, we would like to be remembered for the right reasons, not to be engraved on somebody's tombstone says that because of our negligence, this person dies. Okay. Now, if as an anesthetist, I was looking at the differences in litigations in UK. This was published for 12 years of litigations in the NHS facilities in the UK. And most of you would recognize that ONG is top of the list for litigation. Then comes surgery, medicine, emergency medicine, then becomes anesthesia. When I give this talk to the anesthetists, most of them say, oh, aren't we lucky? We are number 5 on the list. And I turn around and tell them, no, you're not number 5 on the list. You're number 1 on the list. Because for every ONG mishap that happens, the anesthetist is brought in together. For any surgical mishap that happens, the anesthetist gets involved either. And for any medicine and intensive care that happens, the anesthetist gets involved also. So in actual fact, as an anesthetist, I go to the court more common than any of the subspecialties. So in that respect, I took up medical law because I have been to the court so many times and I've written so many expert witness reports. And every time I go to the court, I see a doctor being grilled, made fun of, or sometimes even made as a showpiece in the court. And the doctors usually do not know what their rights are, do not know what the court is like, do not know what the court system, why they are there, how to answer questions, and how to prevent themselves from being put into this position in the first place. So the outcome of this talk is initially I'm going to talk about introduction to the legal system. I think a lot of doctors may know, but a lot of you enter medical school, come out of medical school not knowing what the legal system is. Number 2, you deal with patients. And when a patient complains, what are the systems open to the patient to complain about you as a medical doctor or provider? And 3, I want to talk about medical negligence, which is very specific to us. And 4, I want to know, why are doctors so ignorant about things that affect their profession, their life, even their mental status when they're exposed to it? And number 5, lastly, how can we reduce exposure to this medical negligence in everyday life? Now, we know that there's an increasing awareness of by members of the public, and there's a growth of consumer attitude. There's a new concept called medicalization of social issues, where doctors have to take over social issues, breast enlargement, eyelid. These are not medical issues basically, but they're social issues. They want to look beautiful, they want to do liposuction and things like that. These are social issues, basically not medical issues, but it becomes a medical issue because we are involved in it. And because of this, our litigation can go up much, much higher compared to the normal things that we do everyday life. And thirdly, there's a rapid growth of medical technology. We are supposed to keep up to date, and a lot of things happen very fast. Sometimes we haven't even come up with guidelines, and then the technology is already introduced into the system, and not all of us are up to date with that thing. Fourthly, the teaching in our medical school is not up to par. We teach clinical issues, but we don't teach the doctors how to take care of themselves. The biggest problem about it is the laws that govern our practice and the guidelines that govern our practice. Not many of us come out from medical school knowing them very well. And lastly, communication skills in medical school still has a long way to improve. And a bit of changing trends I would like to talk about later on. So, why are we susceptible? because we deal with life, we deal with the family, we deal with relatives, not only dealing with one patient. And in ONG, we deal with more than one life. We are constrained by our staffing. We do not have enough staff. We are fatigued because we are overworked. And because we tend to refer person to one patient to another patient, like what Prof. Zaliha said just now, there is a gap in continuity of care. So all this will add up to causing a lot of grievance in the patient, and we may be the brunt of the scale, of the outcome of it. And again, as Prof. Zaliha said, not all errors are negligent. So a lot of doctors do not understand the definition of medical negligence, which I will go on in a short while. Now, medicine, as we all know, is an intersection between science, ethics, and the law. The science we are taught in medical schools, the ethics most medical schools will teach you, but the law, not many medical schools will teach you. Because a scientist will say, can we do it? Yes, we can do it. Let's do it. And if you go a bit deeper, it says, we can do it, but should we do it? I mean, patient is going to die. Should you still operate on them? These are ethical issues that you want to know about. But the question you want to know about, if we want to do it, we can do it. Does the law allow us to do it? This is where the big gap is. So if you look at it properly, from my point of view, ethics is the principles of right conduct. It's the rules and standards governing our professionalism. It is something that says what ought to be done. Ethics tell us to strive for higher aspiration. That means we want to be as good as possible taking care of our patient. And the thing about ethics is that it's universal, it is borderless. So you go to Singapore, you go to America, the ethics is all about the same. The ABCDE of ethics. Do good, don't do harm, equality, autonomy. Everywhere we go, it's about the same. Therefore, it is borderless. And if we go against that, there's not much jurisdictional force that will be upon us, except the medical council may introduce guidelines that says that if you go against this kind of ethics, you will be reprimanded. Therefore, if I look at it, ethics is a roof that we look at, we aspire to be. However, if you look at the law, a law is a system that regulates what we do, what can, should be done or should not be done. The law will only take effect on you if you breach the lowest acceptable standard or measure of morality. And below this standard, it is called negligence. Unlike ethics, the law has geographical boundaries. The law in Malaysia is different from the law in Singapore. Therefore, it is not borderless. So you must understand what the law in your country is. Ethics is borderless. It can be trained in England, UK, Australia, wherever it is. The ethics will be about the same. But if you're trained in different countries have different laws. Therefore, the law is very important because it is the basic thing that you must not breach. So to me, the law is something that you have to stand on. So before you look at ethics and look at what is good to be done, you must have a floor to stand on. So you must stand on the floor before you can look at the roof. And this is where there's a reverse happens in medical school. We teach ethics, we don't teach the law. And the law, when it affects you, is going to be more traumatic than the ethics that affects you. So the law now is the one that balances the science and the ethics in a medical practice. So before we go into talking about the law in how we practice every day, you must understand that there are a lot of laws. How do we classify all these laws? We classify these laws as public law, private law, and international law. Public law governs relationship between a citizen and the state. This is a constitutional law, criminal law, administrative law, which regulates the power of the authorities. What we are concerned is private law, which is civil law. It governs the relationship between individuals, between citizens. Contract law, tort law, land law, commercial law. Although there is a bit of overlap between public and private law, but usually public law concerns The government and private law concerns the citizen. And of course, there's international law that governs relationship between one country and another country, which we won't go into. So you must understand where the law comes from. It comes from the federal constitution, through legislation. Also, it comes from judicial decisions when the judges make a decision on certain law. That becomes the precedent for other cases to follow. Islamic or Sharia law, local custom law. And English and Commonwealth laws have been with us for a very, very long time. And if you do not have laws in Malaysia that govern this, that will address this particular case, we can always look at English law and says by the Civil Law Act that application of English common law, equity rules and statutes can be used in Malaysian civil cases if no specific cases or laws govern them. So when point of laws are argued, when you go to courts and you sit down and you see the lawyers arguing, a lot of the cases they use will still be English law and a smatter of Malaysian cases that they use. And the hierarchy of the courts, if you do not know it still by now, the magistrates court, which is the lowest court or the lowest subordinate court, and the sessions court. These are courts of first instance for minor cases. We have the High Court. Most of medical negligence, because they go above a certain value, will start at the High Court. And if you fail at the High Court, you have two chances to appeal, Court of Appeal and the Federal Court. And of course, there are special courts for royalties, for armed forces and things like that, which does not come into our system. So as far as doctors are concerned, we need to know what the Sessions Court comes in if it's a simple complaint. But most of medical negligence will come at the High Court of Malaya and High Court of Sabah and Sarawak. Each state will have their own High Court. KL has its own High Court. Selangor has its own High Court. Penang has its own High Court. So everything starts at Sessions Court, but comes to High Court. And from High Court, it comes to Court of Appeal, which is in Putrajaya, and the Court of Appeal, if it's still not satisfied, it goes to the Federal Court. Now, the Court of Appeal and the Federal Court, they argue on points of law. So as medical doctors, we are not so much involved on Court of Appeal or Federal Court. We are usually involved when it comes to medical negligence in the law at the High Court of Malaysia or Malaya or Sabah and Sarawak. We give our evidence, we give the clinical input at this level. And the judge at the High Court makes a decision. If the High Court makes a decision that we are not happy with when we appeal, clinical issues does not come into it anymore. So it's just very, very important that doctors know this, that their input is very, very important. The first instance they go to the High Court. You must be very, very well prepared and all your data must be there. Next, we want to see when a patient is not happy, apart from pathologies, when the patient is not happy, what avenues does the patient have? He can complain to the hospital authorities. So the head of department or pengarah will take action against you, look at it, take the issue and resolve it at hospital level. Or the patient will complain to MMC. This is basically more of professional misconduct, not litigation. The MMC looks at professional misconduct. That's why you have a code of professional conduct. Okay? Or the patient still not happy about these things and some damages that happen. He or she brings the case to the court, and this is where we have litigation. Rarely, brings the case to court in litigation is usually a civil case. Very rare a doctor will cause himself into the predicament of a criminal prosecution. When he's gross medical negligence, he comes to a criminal prosecution by the state. We'll talk about that in a short while. So the doctors encounter the law in three ways. One is a civil law, which is medical litigation, the outcome of which is damages, you pay. Number two is criminal law. The state prosecutes you, and the outcome is a fine or a jail or both. Some laws put doctors in this category. And number three the doctor will have some professional misconduct, which is usually leveled at a hospital, departmental hospital, or MMC level, and the outcome is a warning, a suspension, or a deregistration. So you must know the difference between a crime and a civil wrong. It is not what is done or omitted in a civil wrong. It is the consequences of what follow. A crime will tell you you cannot do this or you must do this. In a civil wrong, it is the consequences, the outcome. The procedure between a crime and a civil proceeding, a criminal and a civil proceeding, is completely different. And the terminologies that you use when you go to court, whether it's a criminal court or a civil court, how you address the people are completely different. So I've seen both, and doctors tend to confuse the differences between a criminal and a civil procedure. Most of litigation or clinical negligence litigation comes as a civil litigation pathway. Sometimes the death of a patient may lead to a criminal pathway, a criminal suit, especially when you have manslaughter and things like that. The key elements is the duty, the care of breach, and gross negligence. For example, in Malaysia, we have not seen criminal litigation as much as in UK. In UK, if the anesthetist does an error so gross that no anesthetist would do that, then it becomes criminal because it is called gross negligence. Then it can be criminal, then it can be put into jail. And as happens in this case called R. Adamoko, the anesthetist did not detect an ET tube disconnection and in a 14-year-old child undergoing eye surgery. And no anesthetist in the country would stand up for him and says that what he did is inadvertent. And a similar case happened in Kuantan in 1991 when I first came back from Australia after my postgraduate training. And we do not have criminal prosecutions. It's just a head of department issue. Our Attorney General's I think office is overwhelmed with other criminal cases to be concerned with doctors in criminal cases. But in other countries, this is looked at, and I'm sure in the future, our country would follow suit, and you as future consultants must know this. As I said, doctors can be jailed, can come for prosecution by the Crown Court. For example, in UK, if you do unnecessary operations and people complain to you, Ian Patterson, breast surgeon jailed for unnecessary operations, has sentence increased to 20 years in jail, initially from 15 years. Okay, another David Salu, and there's a lot of things that we do not think that is criminal, but can become criminal if our AG's chambers are active about it. So why is clinical negligence different in doctors? Number one, the identity of the defendant. We as professionals have a different standard to the normal population. So our standards are different compared to the normal population to adhere to. Number two, the attitude of doctors. Very rarely a doctor will admit that he has done wrong. The reluctance to admit that he has done wrong is the basis of a lot of litigation. Number three, when the doctor comes to court, the newspapers are very, very happy to print it because it's very rare for doctors to come to court, especially in a criminal proceeding. Number four, unlike other civil cases, medical legal cases take a long, long time to finish, to conclude. And if you are on one end receiving it, if you are the defendant, in the defense side, it can stretch from anywhere from 5 to 10 years. And can you imagine every time you receive a letter from your lawyer or from the court, the stress that you have to undergo? In the 5 or 10 years, you have to think about it. And the thing about medicine is that it is not like construction law or any other kinds of law. We cannot promise 100% success rates. Medical law is not an exact science. Therefore, nothing is predictable. We can say with confidence that it is going to be successful or highly successful, but we can never make promises that it will be successful. That is the problem with medical law, with medical practice. And attitude towards our profession, you see, we break simple laws, criminal laws, we are handcuffed, whether other people break criminal laws, criminal breach of trust for millions of dollars, they can still come to the court in suits with their bodyguards coming, tagging along, and not in handcuffs. Like that. So I'm not so sure why we are treated as such. Maybe I have to look into details why these things happen. So, what is medical negligence? Medical negligence is a tort, a civil wrong, not a crime. Medical negligence is the conduct below a standard of reasonable prudent doctor should do. It has nothing to do with good or bad intention. Therefore, in a crime, it requires something to do bad intention. Only then it can be committed for a crime. And this is called mens rea. The crime consists of actus rea, action that you do, and the intention that you do. In medicine, it is difficult to say that the doctor intends to cause damage, okay, unless it's so severe that his real negligence is called gross medical negligence, then it becomes a crime. Therefore, in most medical cases, mens rea, the intention, is not to do harm. So it is difficult to cause criminal issue. And in medical negligence, you may do wrong as long as there is no harm, which is not called medical negligence, which we'll talk about it. So there must be harm for it to be called medical negligence. In the past, people look at harm as physical harm. But as we progress, everybody will use mental or psychological harm as an outcome, even though they do not have physical harm. That is why most cases we say for pain and suffering as one of the damages put up. So, what is medical negligence? I have looked at medical negligence and say there are 4 components which you all have to know. Number 1, there is a duty that between you and the patient. And the duty can be between you and the patient or you and the third party. It can be not necessarily the patient, the third party is your patient. Number 2 is a dereliction of duty. Most people call it breach. We do not want to break the duty. We tend to disregard the duty. We do not intentionally want to break the duty. Number 3 is a direct causation. That means whatever we have not done right directly causes a damage. And number 4, there must be damage. The duty, there are 2 types of duty. One is a duty of care. And when you have a duty of care, you have to have a standard of care. Previously in Malaysia, we follow Bolam standard in diagnosis, treatment, and advice. But in 2000 something, we changed to follow an Australian case called Rogers and Whittaker. So before this, we used the Bolam standard. The Bolam standard says that if all other doctors or most doctors agree with what you are doing, when you diagnose, when you advise, and when you treat, then you have adhered to the standard of care. But as patients become more informed, they want to know more. And before they give you consent, they want to make a consent on their own, not you make a consent for them. Therefore, after 2007, we followed the Australian case called Rogers and Whittaker, where the advice and consent, it is not for the doctors to decide. It is for the patient to decide. We give the advice to what the patient wants to know, and the patient makes the decision to tell us. We cannot hide between the veil of saying that if I tell the patient he's going to be unhappy, he's going to be depressed or whatever it is, that is his issue. You have to tell him what he wants to know, when he wants to know. You are not the person to decide what to tell and what not to tell. Therefore, this you have to understand. In Malaysia, there are two standards of care. One is the Bolam standard for diagnosis and treatment. Two is the Rogers standard for advice and consent. And the English court in 2015 followed us for one. That in Montgomery case, most of the ONG people who know, in the Montgomery case, the advice and consent from the patient is got to come from the patient's point of view, not from the doctor's point of view. So what are the problems when you have litigation? I told you just now, medical negligence is a long, expensive, and by the end of it, both parties become vengeful, and it is nerve-wracking for the doctor. It stretches years. Unfortunately, the law of innocent until proven guilty does not rarely applies to a doctor. It assaults your credibility. It insinuates that you are incompetent before the judge even makes. Therefore, makes the doctors feel very defensive and view all patients as potential litigants, and like the American system. So why must we teach medical law? We want to teach medical law to doctors because, number one, we want to uphold, and make patients realize that it is a community-centered autonomy and things like that? Or do you want to teach doctors to be very guarded, survivor as a defendant, expert witness, teach you how to go to court and things like that, or defensive medicine? These are two contrasting ways of why we want to teach law, but they are not exclusive. For example, the Americans want to teach you as an institution-centered way of looking at law. They teach you from very early on, they teach you about moot courts and things like that. Whereas the European and the English will try to be more patient or community-centered because they are looking at more ethical rather than legal challenges in everyday practice. Present situation is that in our universities in Malaysia, the universities for a long time have been very unwilling to make medical law as part of the curriculum, which can be understandable because, number one, they do not have probably the people with qualification or experience teach. And number two, if you employ a medical legal lawyer, do you pay him the same as a doctor or a doctor doing neurosurgery or cardiac surgery? So there's an issue of remuneration for the hospital to balance. And because of this, not many people like it. Now, three, the syllabus. What are we supposed to teach you? None of the universities can come with an agreement that we should teach you such and such things. And maybe by the end of few years from now, they have enough people. For example, I'm teaching medical law in the UITM. Maybe this is the 6th batch I'm teaching. Maybe there's enough people to form a critical mass to generate a uniformity of syllabus and bring it as a part of medical teaching for the postgraduate medical law or even undergraduate. Let's have a look at how the UK have done this. This was done by Preston, Shute, and McKim towards effective outcomes in teaching, learning, and assessment of medical law in medical education. They looked at 32 medical schools in UK at that time. And when they were looking at that, we have only 16 medical schools. And within a few years, within 16, we have 32 medical schools. There was a sudden explosion of medical schools in Malaysia. And that was when I was doing my master's, and my thesis was, are we teaching medical schools, are medical schools teaching doctors about medical law? So what did Preston, Shute, and McKim found out? They found out there's a lack of coordination of teaching medical law between preclinical and clinical education. The people in the clinical side, once the doctors come to clinical, The tutor said, we don't have time to teach you because there's so many things for you to do. Ask the preclinical people to do because you're in the classroom, easier to teach medical law in the classroom. But that defeats the purpose because learning in preclinical school is distant from what you practice. You may learn in preclinical school. When you come to clinical sessions, you have forgotten all about it. Number two, learning medical law is opportunistic rather than structured. I can teach you, but I cannot show you. I can teach you heart failure. I can bring you to CCU or medical ward. I can show you what heart failure is, the signs and symptoms are. But if I teach you about medical law, it is very rare I can find a case to show you. It's always a previous case. And it's opportunistic rather than, and when we have a medical legal, then we want to bring everybody in to show. And that doesn't happen very much. And when they say they teach medical law, they actually focus more on ethics to develop professionalism, which is good. And in UK, the problem of EU requirements are coming in and things like that. So autonomy, rights, discrimination becomes a big issue. And if you look at UK, 64% of medical law is being taught by clinicians. And one of the things they say why medical law is not in the syllabus, number one, it's not practical. Number two, students has had enough assessments, so we don't want to assess them anymore. And number three, it was never part of the clinical curriculum. So why should you include it now? We have to progress. Come on, okay? But if you look at US, in 1952, when they did a survey of all medical schools in US, there's 72 medical schools in 1952, only 22% teach legal medicine, but there was no details of what was being taught. 20 years later, the figure doubled. Okay, only in 15 medical schools it is compulsory, and some of them, most of them, were examinable. So they were examined on medical law in medical school itself. 20 years later, the figure doubled again from 20 to 40 to 80. And now 40 of the medical schools out of the 74 makes it a compulsory requirement before you graduate. And 33 medical schools has an elective of medical law. That means you sit with a lawyer, go with a lawyer, go everywhere. I actually did that beginning of this year. I spent 1 month with a lawyer who has done a lot of medical litigation. I spent 1 month with P.S. Ranjan. Spend the time in the office, go to them with the courts and things like that, and see how a lawyer representing the plaintiff works. Because before this, I was writing a lot of reports for medical defense, for all the medical defenses, for all the doctors. And this year, I went to see what the patient looks at. And I can tell you, the patients have got a lot more grievance about the doctors. Unfortunately for the patients, very, very few lawyers specialize in medical law. That is why doctors have been spared a lot of the times compared to America. Whereas doctors, when they buy defense for themselves or medical indemnity for themselves, they normally join a company that have got a group of lawyers specializing in medical defense. Therefore, doctors are well prepared when they go to court, except for those probably in Ministry of Health, because the AG does not has a small group only to represent doctors in the whole country on medical defense. And there's a fast turnover in the medical legal circle in the MOH, in the AG's chamber. Therefore, in a way, it can become a bit disadvantageous. So I did a survey in 2014 for my master's, for my LLM, and I interviewed 172 junior doctors who are about to enter service in the Ministry of Health. And my first question is, medical law and ethics, is it important? 100% of them say yes. How much are they taught? It varies from 2 hours to 40 hours over 5 years. And when I asked them to list down what topics they were taught about, mainly 80 to 90% were taught ethics, not medical law. And some medical schools teach 2 hours of medical ethics for the whole 5 years and say, I have achieved what my MQA have asked me to do. How many of them are assessed? 15% said they have formal assessment, more of medical ethics rather than medical law. 80% says there was no formal assessment. Therefore, Why teach them if you're not going to assess them? That is why they are not interested, because you do not impress on them, which is important for the future. No point teaching somebody if you're not going to assess them. It's just wasting your time. And 90% of them says the information is via lectures. And 26% they say they did not enjoy the subject. Maybe it is non-science based. And in Malaysia, 100% of medical law or medical ethics is being taught by doctors. Now, whether these doctors have got the qualification, the experience, or the know-how, or the knowledge is a different matter. Only about 14.5% invite lawyers to come and give medical legal talk to doctors in training in their final year. And I'm surprised there are 3 universities in Malaysia actually employ an ethicist. There are ethicists in this country. And since my teaching at UiTM, there are quite a number more coming out as ethicists. So you'll see a lot more ethicists. Most of the time, we teach medical law and medical ethics to doctors, mainly the old doctors, people like me, people like I won't say Prof. is old, but elderly doctors who have seen a lot and understand ethics, understand law, and we teach. But we have not got medical formal training. Some of us have gone into the medical council and things like that. So we see a lot more, so we have more knowledge to talk about it. But when it comes to medical law, very, very few doctors have legal background and can teach you medical law. So what is important is, even if we teach you medical law, when you become doctors and become consultants, you forget what you are being taught. And one of the problems is, for example, this is a survey done in Netherlands where the standard of care is very, very high. And they talked about, this is only looking at informed consent. They look at the 10-year statistics of people coming in for disciplinary board and court litigation. And they took out consent as one big issue why they come to court or disciplinary procedures. And they found that of all the cases, 1 in 6 surgeons, specifically 1 in 7 orthopedic surgeons, the complaint against them was related to consent. Okay, 60% of claims because the complainant was female. As you know, female wants to know more about what's being done to their bodies. Men will just say yes, 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 and accept everything. So when you take consent from female, be more careful. Was the issue in medical disciplinary board decisions in about a quarter to about 40% of cases. And for clinical surgical specialties, specialties, 82% of all claims are litigation. And unfortunately, if you ask the doctors, very few of the doctors agree that something went wrong when they take the informed consent procedure. Now, informed consent is a big issue with me and with a big issue with a lot of people. There are informed consent guidelines. We are supposed to follow informed consent guidelines. But when you join a university or join a department, has anybody teach you how to take consent? We just followed how consent was taken by our seniors. And our seniors happen to be medical officers or specialists. And sometimes the medical officers are probably 1 or 2 years more senior than us. And they followed from previous doctors. So, but the informed consent is a very, very important thing. I will talk to you about informed consent because one of these issues is my interest, and I'm going to talk about it in sometime this month. So from my point of view, as doctors being trained to become specialists and later consultants, inshallah, what is it that they want to know about medical law? They don't want to know everything about medical law. What is the gist of medical law that really you want to know before you start practicing? Number 1, you have to understand Malaysian legal system. Number 2, you must know what medical council guidelines are about. and medical guidelines and law is all about. Number three, you must understand what is the definition of medical negligence. It's so easy to say, oh, that's medical negligence, that's negligent, but you do not understand what it means. You must understand this. Number four, if you really know medical law, then you'll have to know important cases in Malaysia of medical legal significance. For example, Fu Fiona, or Hasmina, and things like that. So these are the cases that you have to know. Number four, you have to know if the patient complains, what are the avenues that the patient complains, and how you can overcome or how can you be prepared when these complaints come to you. Number five, you want to know if you're complaining about professional misconduct, you go to MMC, what are the steps, what are the procedures? I think Dr. Zaleha and Prof. Mahmud has spoken about that just now. So there's a bit more detail for you to know, because when you come out as specialists, you are responsible for your medical officer's conduct. Okay. Number five, this rights of disadvantaged group. Now, knowing medical law is not about medical litigation only. You must know the rights of children, the rights of the OKU, the rights of elderly people, the rights of mental health, not because you want to protect them, protect yourself, but because you want to protect them from unscrupulous society or medical intervention which they may or may not require. So medical law is not only about medical negligence. There's a lot of things you can do in medical law, protecting the rights of all these rights of all these people. For example, Medical Legal Society has been organizing the last 2 months, and it's called Speaking for the Unspoken. We talk about people who are in the jail, prisoners, what rights have they lost, but to medical healthcare accessibility. Talk about homeless people out on the streets, what rights do they have, healthcare rights, domestic violence, children, people who have mental capacity and things like that. So we have had 2 webinars in the last 2 months. Okay. Number 3, when you all graduate, become specialists and doctors, consultants, you want to know how to write a medical report in a medical legal litigation, and you all be called, irrespective whether you like it or not. The government will say you become the expert witness for this case, and you have to know as an expert witness what are your responsibilities, what you have to do, and how to conduct yourself in court. Other things you need to know is litigation. Why people still bring to court? There are alternatives to litigation. They call it ADR, alternative dispute resolution. For example, mediation. That is why I did a mediation course with the Bar Council to see how we can escape, how can we avoid litigation and do more amicable forms of conciliation. So, suggestion forward is for the universities to agree on a university, put the medical law and ethics as a separate subject, so make it compulsory for them to know. 90% of you, 80% of you are coming from Ministry of Health. If you are not taught about medical law and how to protect yourself, you go back to the Ministry of Health, you become specialists there, and whatever you do, the Ministry of Health have to take care of you. So all the litigation in the Ministry of Health is because you are not taught about it. And I will show you some data on what the Ministry of Health is spending every year. Okay, and we have to encourage doctors to be a bit more in depth about law and ethics, and have to engage lawyers to come into medical school. Even though there is rivalry between the so-called rivalry between doctors and lawyers, we have to come up to a common ground that both of us can benefit. Okay. And I mentioned this, I like to show this slide because I'm an anesthetist. Communication skill is one of the big issues, or the biggest issue in medical litigation, because we do not talk to the patient, or we talk to the patient from our point of view rather than looking at the patient and talking to the patient from his point of understanding. For example, he says, your surgery will be done using local anesthetics. And the patient thinks local anesthetics, things that are produced locally. So he said, give me the imported stuff. I'm more confident with that. So Communication skills, not only between doctors, I mean, we are taught among doctors, we can talk technical terms, but when it comes to patient, you have to talk it from a patient point of view. Some data from the MMC Council, if you can see, Medical Review Panel, MRP, it has always been going around 20, 30, 40, 50. Suddenly in 2013 and 2014, it shot up from 77 to 300 complaints by the public or by the hospital about doctors working into them. Now, I'm not so sure why, but some people have told me that because the large of graduates from so many medical schools suddenly coming out between 2011 and 2012. And if you look at complaints against doctors in the Ministry of Health, it is slowly increasing. This is medical MMC data, MOH data, not MMC data, MOH data I got through my friend. Okay, it runs around about 170 to 215, it's slowly going up. And if you look at it, there's about litigation is about 50 to 70 cases per year. Whereas ex gratia payment, and if you don't go to court, the Ministry of Health pays the patient direct, therefore that solves the problem. Out of court settlement is about double that. But for every ex gratia payment, which is about 67,000 ringgit per case, averaged over all these cases, that the litigation cost is nearly 10 times more. Ex gratia is only about 70,000, 70 something thousand, but litigation cost goes up to 600,000 per case. So even though the cases for litigation is half, but the outcome, the cost that you spend, the Ministry of Health spends, is a lot. And the Ministry of Health actually doesn't pay for it. Maybe that's why they are a bit complacent about it. All the money comes from Ministry of Finance because it is not budgeted for in the Ministry of Health punya budget to take care of litigation and ex gratia payment. So if it were to come up from the Ministry of Health punya budget, then the Ministry of Health will be very, very upset. And lastly, there are many ways that we can not litigate. Alternative dispute resolution. Apart from litigation, there's arbitration, mediation, negotiation, conciliation. I did mediation because overseas in Australia and UK, medical disputes are resolved by mediation, and a lot of things get settled down very, very fast. A case can go on for 5 or 6 years, but mediation takes 3 to 6 months and it was settled, and both parties. If you see a litigation they call it charge, not charge, litigation, they call it, what is it? There will be 20 or 30 things that the lawyer will allege that you did do or did not do. And it's just not necessarily what the patient actually complained about. So when you go to mediation, we just want to know what is it the patient's main complaint. And we address that issue. And we can settle it. And a lot of people see that once you do mediation, about 50 to 60% of all issues can be settled. So half of the data, half of your cases can be settled by mediation alone. And if you look at Singapore Medical Council, any public patient that has a complaint to the Medical Council goes to mediation first. You must resolve that mediation. And if mediation fails, then only it comes to litigation. Whereas in this country, if the patient is not satisfied, the first thing they do is litigation. Mediation is not even proposed as an alternative route. That means which lawyers are not that keen because it means less revenue for them. So they encourage litigation. So if you look at it, Singapore SMC, Singapore Medical Council, has made it compulsory. If a public patient comes and complains, whether it's litigation or professional misconduct, you go mediation first. If the mediation is not done, then only you go to litigation or medical counsel issues. And how can we reduce? My teaching of the medical doctors in University UITM, I've summarized into simple ways of how you can avoid litigation, avoid being exposed to medical negligence. My ABCDE. A is the awareness, which profession you're in, what your susceptibility is, how are you going to indemnify yourself. A lot of people indemnify themselves not knowing what their limit is, and then the suit comes up to more than what the indemnity is, then they have to pay out of their own pocket. For example, you indemnify for 2 million ringgit, and the case comes out, the judge says the patient will receive 3 million ringgit or 4 million ringgit, then the extra 2 million ringgit that is not being paid for by your indemnity, you have to pay yourself. Susceptibility, who are the people that are going to be susceptible? Primary person, secondary person, third party insurances, whether they're covered or not covered. B is beware of the service provider. For example, an anesthetist, I have to beware who is providing the service, the surgeon orthopedic or whoever is providing. I must know that fellow's capability. I must be aware of the patient, and in Malaysia, the patient and their relatives, which is more important. A lot of times I receive calls the night before bypass. Some son from Canada rings me up and say, "Have you seen my patient, my father? Have you spoken to my father? Do you tell my father this and this?" So in Malaysia, it is such a big issue because relatives play an important. Autonomy is overruled by relatives in this country, whereas in overseas, autonomy is autonomy. C, the three C's: care, consent, comments. I think that Mohamed and Prof. Zaliha brings up comments by other doctors to about other doctors. In other countries, other doctors who comment about other doctors' profession can be taken to court for slander, or can be taken to court if in writing, can be taken to court for other things. In Malaysia, nobody has done that. And you find that comments are usually done by specialists in another specialty which has no idea about what your specialty is doing. Consent is a very, very big issue, which will become more common nowadays. I'm talking about consent in the MLSM talk in a couple of weeks' time. How we have to practice defensive medicine, whether it's active defensive medicine or passive defensive medicine. Active defensive medicine means you rule out nearly everything, for example, in private practice, to make sure that you are covered, which becomes expensive through the system. Of passive defensive medicine, know your limits, know what hospital limits are, know the people assisting you what their limits are. If you cannot do it, always refer to somebody else, or discuss and have group discussions between other subspecialties, because patients are becoming older. When they become older, they have multi-organ disease, not only the area that you are going to operate on or taking care of. So you have to discuss with other people. In IJN, it's not just that we have to treat the heart. The patient with the heart disease will have renal dysfunction, will have lung dysfunction, will have a stroke in the past. His diabetes, his endocrine is not well controlled. So if you're a surgeon, you're just looking at the heart, you're not going to have an outcome, a good outcome. So you have to have multidisciplinary, and we have good multidisciplinary meetings in our hospital, especially with the pediatricians in the obstetric side. So an obstetric patient usually comes to us with a congenital heart, or they're going to have a medical problem, or they have had they want to have family planning, but they have a congenital heart and they have vital valve, whatever it is. We discuss with them when to deliver the baby, whether it is by cesarean or whether it is safe vaginal delivery. Depends. So we have once a week, every week we have an ONG, pediatrician, anesthetist, pediatric cardiologist, and adult cardiologist sitting down discussing cases. And education, I told you the importance of training, the importance of being an expert witness, and the importance of alternative ways of taking care of the complaints. So the question is it the act of being negligent or the knowledge of medical negligence and how to avoid it? We do not do medical negligence by intention. Therefore, it is our knowledge and how to avoid it is where we are lacking. So my question to the university is, are we negligent if we do not teach medical negligence to you people who will be coming out of medical school and exposed to medical negligence? So medical negligence is not only about the patient, is about taking care of the students that you're going to train. So you can go up and say, I was not taught this in medical school. Lastly, one famous lawyer had a talk at the arbitration center. He says, this is Justice Gopal Sriram, who has now retired. He was in federal court. He says, lawyers have no right digging into doctors' backyard. Now, he has done a lot of medical legal cases, and he actually has a medical legal issue, but he has been very kind to doctors, and he doesn't think lawyers to come after doctors. But the plaintiff lawyers in one of the talks says that lawyers have a right to protect their clients or their patients' welfare. So my advice to doctors is that doctors should know where their backyard extends and how to guard it. So it is very, very important. My last slide, second last slide, says malpractice makes perfect. And I can assure you, one malpractice claim to you, or you undergo one medical malpractice, the trauma of it will make you do perfect recording, documentation, and taking care of the patient in the future. This is just an advertisement, and I am the vice president of the Medical Legal Society. We conduct medical legal education every now and then, and on the 19th, we are going to do Medical Legal 101. I'm going to talk about consent, which I think is very, very important. I'm going to talk about consent. Unfortunately, I'm the only doctor talking in the seminar. Venu is going to be the chairman. Dr. Mark is going to be the moderator. The other four speakers are lawyers. I'm the only doctor. The lawyers will tell you what to do. For example, Dr. Harris is going to talk. Mr. Harris is going to talk to you about confidentiality. Importance of Charlene is going to talk to you about maintaining good medical records. Datin Ani is going to talk to you about working with the medical legal lawyers when it comes to a medical legal claim. How do you go about what are the things you need to do, or how to expedite things and not make things difficult. And Nurul Huda is going to tell you some important cases in the Malaysian scene over the last few years, which is very important because it shows a lack of understanding among doctors in this country. So, has medical school prepared you to practice in the medical legal landscape? There you are. You can only answer, the universities can answer that. Okay.
Okay. Thank you so much, Dato, for that brilliant talk. Okay, I thoroughly enjoyed it. And I think as with our other two speakers, we still have a lot to learn. I think it's not just the new students who have come on board, certainly for all of us, including myself. And I do take note, Dato has quite a number of questions for the universities. So maybe Dato, maybe we are now taking baby steps, right? So maybe this is the first of our baby step. So we are looking. We hope to have a series of such things, and maybe one day, like Dato mentioned, when there are enough people around, or I think we should seriously look into the matter of teaching medical law, some principles of it. Yeah, but we are now taking baby steps.
I did medical law because I've been an expert witness for a while, and I see there's a lack. Doctors go out on the stand and they get butchered by the lawyers. So I took up medical law to defend doctors. So my intention is to come back to university and teach doctors law. I could have easily gone out when I retired a few years ago and joined a law firm and worked on the on the other side, on the dark side. But I've refrained. I still think teaching medical law is an important thing.
Yeah, thank you for that passion, Dato, because I do note that you took your master's in 2015, right? So yes. So okay, maybe
it's
what
not too
we
late.
can do is yes. It's lifelong process. I just mentioned to the students that medicine is a lifelong learning process. So I think there are a few questions. Maybe some